This is Craig Huston, your Summit Series host. Welcome to our podcast. The Summit Series is your behind-the-scenes pass to building real value and preparing for what's next, whether that's scaling, selling, or simply stepping back and enjoying what you've already built. Let's dive into what actually drives great outcomes and how you can make them happen. Hey, thank you all for joining the Summit Series. And this episode, we have Addison Watson, a transaction attorney, who's going to join us and talk to us about what it's like to be a business owner going through a transaction and why you might need legal counsel and when you might need legal counsel, and some of the pitfalls that people go through, some of the blind spots that people might have. And so, Addison, thank you so much for taking time to join us today. Really appreciate you being here.
Yeah, I'm looking forward to it, Craig, and I appreciate you having me on. Thank you.
Yeah, so first, man after my own heart. So the name of your company is Summit Legal Services or Legal Consultants, and my company is Summit Achievers. So we have that in common. That's pretty cool.
Because we want to be at the top, man.
That's right. That's 100%. That's exactly right. So do our clients, right? We want to help our clients do that as well. And one thing we don't have in common, though, I noticed as we were preparing for this, you don't like ice cream or chocolate.
I don't, man. So I grew up, it's a long, convoluted story, but I grew up in rural Mississippi, Starkville, Mississippi. If anyone's ever heard of Mississippi State, you can see my cowbell hanging out up there, near and dear to my heart. Don't tell my law degree from Ole Miss right behind me, but I grew up in rural Mississippi. My mom was a dietitian by trade. So although she went into real estate, the dietetics really stuck around. So no soda, no ice cream, no chocolate. So when I went to friends' houses, what did I drink? I drank whole milk because all we had was skim milk, and that was my ice cream.
Okay, you indulged. You indulged.
That's right.
Friends' house. That's awesome. You know, I wasn't really a big ice cream guy, but when I graduated from college, I bought a place and decided, wow, it'd be really smart to have somebody help me pay for this. And a friend of mine was looking for a place. I had him move in. He was a architect, and he moved in and took over my freezer. I'm not going to mention the brand, but it's a brand known for very rich ice cream. And his saying was, no meal is complete without ice cream. And he wasn't kidding. Ice cream after breakfast, ice cream after lunch, ice cream after dinner. Just from living with a guy for a while, you end up eating ice cream. And so I have to admit to a little bit of ice cream almost every night. So we're on the polar opposite there.
I was fortunate enough that my wife married me before she learned about my ice cream hatred and chocolate hatred, because she loves ice cream, and she loves it. So
she doesn't have to worry about sharing, though. That's good.
I accept it. I don't shun ice cream. If people want to eat it around me, it's okay. I'm not going to partake 95% of the time. I make bad decisions 5% of the time, and that's okay.
That's awesome. So tell me about law. Why law?
Yeah,
rural Mississippi, and you end up with a law degree in Alabama.
Very, very strange path. But even I was one of those kids in high school that was kind of, I knew what I wanted to do, and I didn't ever stray from it. And I actually enjoy what I do, which is not very common. So I grew up rural Mississippi. My parents divorced at an early age when I was 8. So it was me and my mom for most of it, my brother and sister. And then my brother and sister in high school ended up moving out and going to live with my dad in Ohio. So it was just me and my mom and our dog. So, you know, it was one of those things where I grew up a little bit quicker on that front. But I always grew up super competitive with everything that I did, which naturally lends itself to law. So whether you know it or not, Craig, you may not even know this, but I grew up playing soccer, and I ended up playing soccer in college as well. And so it's just always been that competitive drive for me of pushing to try to be, you know, frankly, the best at everything and to win. One of my sayings that I think encompasses me as a person is, I hate losing more than I like winning. And so that tends to lead to a competitive career path. And that's what got me intrigued in the law at first. I really got introduced to legal concepts through John Grisham. And you'll see my collection up here. I mean, there's maybe one or two that I haven't read, but if a new one comes out, I know what I'm getting for Christmas. I know what I'm getting for my birthday. Like, my wife knows the stand. We have an SOP for this. If there's a new Grisham out, like, I'm getting it for the next holiday. It's awesome. I love it. But he also blended the concept of being able to become a lawyer, even from a place in rural Mississippi.
Yeah.
And so for a lot of people, it doesn't feel achievable until you kind of see somebody who's gone through those steps. And so that introduced the concept for me. I started reading that at an early age. And then I was like, this could be really cool. I'm hyper competitive. And then I learned that law school was you get ranked in your class. And I was like, oh, this sounds fun, right?
Yeah. Yeah.
So I really enjoyed that aspect. And so knowing that I always wanted to do like contractual and transactional work is something that a lot of kids in high school really aren't thinking about, but that was always what excited me. I love the idea of constantly learning and finding out new things. If someone asks you a question and you don't have the answer, that's the most frustrating thing in the world to me.
Yeah.
And I always felt like lawyers knew the answers. And so that was a big driver for me to go to law school as well. And then, however many years later, here I am. I'm still doing it. I love it. I've shifted my practice from some of the larger companies that I work with, and now I try to keep it more focused on founders and founders who are exiting their businesses. So it's been a great career path so far, and I've got 20 or 30 more years to go. So I'm looking forward to those 20 or 30 years, and there's not a lot of people that say that about their job.
Boy, that's for sure.
Yeah.
So, okay. Important question. How many times have you watched The Firm?
Oh man, this is another great reason that,
Yeah.
I married my wife. She loved those old John Grisham movies, The Time to Kill, Pelican Brief, The Firm. So man, we'd watch those all the time. Well, since we've been married, we've watched The Firm at least 5 times. Like
Yeah.
any free streaming service that exists with it, we're on it, man. Baby goes to bed, it's like, we could watch something new from Disney or The Firm.
Yeah,
Firm is
that's
great.
right. Let's watch The Firm.
Yeah,
We just
that's
rewatched
it.
it actually recently too. Great
It's
movie.
so good.
It is. It is. So you worked for a larger firm early in your law career, and you decided you wanted to do your own thing, kind of carve your own path. But you've had experience selling billion-dollar companies and smaller companies. What made you kind of focus in on starting your own thing and narrowing the focus on more of the smaller privately held businesses with owners that want to transition?
Yeah, so that's a great question. I'm incredibly grateful for where I started my legal career, a large regional firm here in the Southeast. I had some of the best partners to possibly work for. They took the time to mentor me from a kid who had just graduated from law school to really shape me into being what it means to actually be a lawyer and not just think like you're in law school. So I was incredibly fortunate for that experience. But yeah, like you said, we did crazy things that I would consider crazy. Even now, I think about one of the deals that we did, and it was one of the last deals I worked on. We were selling a power plant that was based in Canada, but in order to make the sale and do the most effective tax transition of that income, we had to route it through the Netherlands back to the US because of the tax treaties. And I was like,
Yeah.
how do people know these things? Like, right, it's crazy. We were getting involved with people who were $3,000 an hour to help us with this. And it was a really neat concept. I enjoyed that aspect. I got to learn the really complicated deals and learn a lot about the regulatory framework of all these, energy companies and plants and federally regulated things. But I would switch regularly between those sorts of deals and the guy in Alabama who's selling his garage door business for $600,000.
Yeah.
And the one thing that I noticed between the two is the person who really needed more help was that guy who was selling his garage door business, because the $1.2 billion transaction, they've been preparing for this sale since they bought the generating plant.
Yeah.
But the guy who's down in South Alabama, he's put his heart and soul into this business. He got a 10K loan to start the business. His wife doesn't work, raises their children, and this is his retirement plan, making sure that he's able to sell what he's built his entire career on and being able to keep that money. And so frankly,
Yeah.
for me, it was so rewarding to finish that deal. That's not something that a lot of the larger firms put on their website, helped this guy who has no name recognition sell a business for $600,000. But for me, like, that should be front and center. I thought that was the coolest experience, and being able to do that for people who truly value your advice, your mentorship, and it really stuck with me. So I loved where I worked before. their client base was massive companies. And that's great. Like it was really cool to get that deal experience. But I also didn't see myself feeling that fulfillment like that for the next
Yeah.
20 or 30 years and having that excitement that I do today. The way that I get to run my business is however I want to run it, which is really cool.
Yeah.
A lot of law firms will start and do a partnership track that's very rigid. It doesn't matter if you're, the best person that's ever come through their ranks, 7 or 8 years until you make partner. And then from there, you're still in this tiered structure based on seniority. And so for me, I was like, you know, if I'm competitive and I want to be the absolute best and I don't get rewarded for being the best, those incentives don't align. So after getting that experience and figuring out where I truly wanted to be in the transactions market, I was like, I feel like this is something that I can do and I can handpick clients. I can choose which matters to work on. And at the end of the day, I can work on the things that I'm excited to get out of bed for. And I
Yeah.
can take podcast calls with awesome people like you and do that between deals. And I love having that autonomy. And it served me really well. So I left about 5 years ago and started my own practice, and I have never looked back. I've never regretted it one time. And there's a little bit of the risk taking entrepreneurial side, which I've always had, and a lot of lawyers aren't like that. So I feel like I can also relate to the founders in that aspect as well, because they've all taken significant risks to get where they are, and so understanding that, I can serve them better.
Yeah, it's the entrepreneurial road is very unique, right?
It
You have
is.
instant feedback. I like to tell people in our businesses, if you're working for a big company, you have some form of paycheck that is some form of regular for the most part. When you're out on your own, hey, you're either billing or you're not billing. It's a very on-off digital metric. And so you really know instantly whether you're doing well or not. So it kind of feeds that competitive spirit. And like you, I think I hate losing more than I like winning. It's just not a good feeling to come in second or third. So trying to make it happen, that's good. And so, yeah, congratulations on that. And, for the people who do what we do, meaning they go out and start their own business, they work hard, they build this thing, like your example with the garage door business. These people, for the most part, they're going to sell their business one time statistically, right?
Right.
Oftentimes people who are buying, particularly if it's any kind of large firm, private equity, they're, putting together a portfolio of companies. They buy and sell businesses all day long. And so you have what I would call an unsophisticated seller. And that doesn't mean that they're not smart. I mean, they're very smart building a business. They just don't know what they don't know. And they're sitting across the table from very sophisticated buyers, right? And as I
Right.
recently shared with a client who was talking about how friendly the other side of the table was, I said, yeah, they may be friendly, but they're not your friend. They're just fishing for information that you're willing to give them that you don't have to help their case and put them in a position to make a better offer, because they're looking for a deal. And we also know statistically 80% of businesses don't sell, which is pretty brutal statistic. That's one of those you kind of sit there for a minute and go, can that be true? But it really is true. And so for that garage door person that really needs that for retirement, it's important that that business sells, and they just don't shutter it one day and, wow, it was a nice try, and it's kind of the end of the road. So let's talk about how we help them. Just from a legal standpoint, everybody thinks, oh my gosh, that attorney, way too expensive. This is going to cost me too much. I can go online. I can Google this. There has to be a YouTube video, right, on how to sell your business. But what are some of the common legal blind spots that business owners kind of overlook, when they're preparing for a sale, and how can they plan for those ahead of time and be proactive?
Yeah, that's a great question. So one of the things that I want to add into your list of YouTube and Google searches is everyone says, I asked Chat GPT this. That's
Yeah.
always like one of the first things I get when I meet somebody. And I'm like, that's great. I'm glad you're being resourceful, but there's a reason you reached out to me, right? Like you want somebody who's been there and done this. Chat GPT hasn't done this. So one of the things that a lot of business owners forget when they're smaller businesses is The buyer is going to come in and look at the business, and they're going to look at all the assets that the business owns. So one issue that I see a lot of business founders and operators make is they begin commingling their personal assets within the business. And I've dealt with this a ton of times. One thing we always encourage them to do, and this is, again, we'll touch on some of the LOI stage type stuff, but this is where your role and my role are truly there to help people understand what a buyer is going to be looking for. A buyer is looking, and it's a very cold term, but it's just they call it a target. They're looking at a target. The business that you own and have spent your lifeblood creating, to a buyer, is a target. Because their goal is to win. They are going to operate your business for profit. And that is a great thing. That's not a negative thing at all. I want to give that connotation. But you're going to have that personal attachment to the business. You're going to think it's the greatest business in the whole wide world, right? And that's a great thing. But the buyer is going to look and try to find all the ugly pieces of your business. Like you talked about, lawyers being incredibly expensive and there being this overweightedness between a buyer and a seller at the negotiating table. All that's 100% true, Craig. The way that you can put it back in your favor is actually, instead of trying to pinch pennies on that dollar, because you don't want to hire a business consultant ahead or a lawyer who's experienced with transactions, you can if you engage those people early enough, what you have paid them will pay off tenfold. And I guarantee it. Let me give one quick example. So I worked with a business purchaser, and they asked me, what my flat fee would be or they asked hourly rate. I typically like to work on flat fee, which we can get into, but they were purchasing an event business down in Tampa, Florida. And I said, hey, really like to be involved. Here's my flat fee, which is always lower than what everyone else quotes for the most part, for the large firms. But, I still respect my time and experience. So it might have been like 15K, 20K, something in that realm. It was a bigger purchase. And they said, hey, there's a transactional lawyer the seller wants to use, and he's not going to represent either party. He's going to represent the transaction. I said, hey, let me tell you, I truly don't believe. Yeah. Right. I said, look, is not in your favor. That doesn't work for anybody. You can do it on a real estate home purchase for $350,000. Sure. Understand. You're buying a business for $5 million. Please don't waste money on this. I didn't hear from him for another month, Craig. And then one day in my inbox, I get all these deal documents. Hey, can you spend 20 minutes to make sure we're buttoned up? And I'm like, guys, 20 minutes to look over an APA that's 35 pages, a bill of sale, all these different things. I'm like, guys, I can't do this in 20 minutes. I would love to help, but if you want me to go through and point out issues, I'll red flag some stuff. They said, all right, 30 minutes, just look at the lease. I said, all right, guys, I'll do that. Gave them feedback. Saved them money. Let's say my time's $500 an hour. So I paid $250 for that advice. I probably saved them at least $10,000 over the life of the lease. It's a small investment for a big gain. But I was asked not to look at any other deal docs. 2 weeks after closing, Craig, I get a call. We got screwed. This is complete BS. I said, hey, what are you talking about? I don't know what happened in this deal. They said, I'm sending it to you. So I get the final APA that's been signed. I looked at it, and he said, there was a bucket truck on the lot when we did a look around the property. It's non-functional. We had it listed as a $70,000 asset, and it doesn't work. I said, well, let me go look at your reps and warranties about what you purchased. Sure enough, they bought everything as is, where is. They've done all their reasonable inspections. Buyer or seller can't be held liable for anything. Craig, I never would agree to that. There's no chance that I'm agreeing to that. It's got to be at least an operational condition for its age. And it's a small thing like that where you try to save, $1,000, $2,000, and it cost them $70,000 on the back end. And there's an educational aspect where our job isn't to tell you how to run your business, or at least my job isn't. My job is to tell you how to get the most for your business or protect yourself as much as possible when you're doing a business transaction. And some people they understand that lawyers are mean, we're expensive. And a lot of people have their first interaction with a lawyer. It sucks, right? It's usually when you're getting sued, you're paying your lawyer, you're going to pay a judgment or a settlement in the future, and you just feel like everyone's working against you. This is an opportunity for everyone to come together on the same team. Your CPA, your business coach, any consultants, your legal team, we're all here to support that transaction. So making sure that we're there to support along the way, pre-LOI, get your business house in order, separate all the personal from the business. That is such a big deal. And I think that's a big step that a lot of founders miss in that process.
Yeah, and I think they sometimes don't recognize that we're sitting on their side of the table, right?
Right.
We're on their team, and we want them to win. So it's not about the next hour being billed or trading time for money. It's about bringing expertise to the table. Just like you were sharing that crazy transaction where you have to move something offshore and back onshore for taxes, and you're like, you even said it earlier, like how did somebody even know that existed, right? So
Right.
business owners don't know what they don't know, and again, not everybody is honest. You'd like to think everybody is, and everybody's up front and they're great, and people will smile and they'll shake your hand and they'll tell you what they think you want to hear, but they'll also cover themselves in the deal. And so whoever, everybody on both sides actually needs a good team, a good, strong team. And it's so important.
Right. And one thing I want to touch on that before we go on, because you mentioned us all being on the same side of the table. And that is 100% truth, Craig. One way that I try to help founders understand that is, I mentioned it earlier, but switching more to a flat fee concept rather than hourly. That way, a founder doesn't weigh the question in their own head and make their mind up about the liability and risk before they pick up the phone and call me, right?
Yeah.
My job is to be on your team, be accessible. If you have a question, that question could save you thousands, tens of thousands of dollars. I want those questions to be lobbed at me. Give me the questions you have. When you're on a flat fee arrangement, that client doesn't think twice about calling you, which is great a lot of the time. Now, sometimes, there's some drawbacks, and you got to be like, hey, like, I don't need to tell you how to like heat up your steak or anything like that, right? But you do get a lot more of that working relationship when you switch from the hourly to flat fee, from what I found. And the hourly, a lot of founders and business owners feel like they are constantly battling the question of, am I going to pay $300 for this call? Is this call going to be $400? And it might not be worth it. Whereas if you're on the flat fee, it's, hey, this person's here, they're on my team, they're here to work for me, no matter how much or how little. And I have found that to be a huge turning point, at least in my own practice.
Yeah. As you were talking about that, I'm thinking about some of the things that these guys and gals will do with their business. Oftentimes, they're just busy, right? They're busy making it happen every day. They've got clients to serve, employees to pay. Sometimes it's very stressful. Sometimes life is going well. They've got insurance and rent and taxes, and they have a lot on their mind. And so sometimes they have an intention to take care of stuff, but it just gets lost in time, right? And a week becomes a month, a month becomes a quarter becomes a year becomes 5 years, 10 years. And when due diligence comes, it's like 5 back-to-back colonoscopies, right? I mean, business owners really underestimate what due diligence is like. And when you talk to people who have sold their business, they're like, that was a brutal experience, right? And it can take a very long time. And it can just sometimes be a way that buyers wear you down as well. Just keep asking and keep asking and keep asking, because they want you to kind of get to a point where you're like, look, dude, I'm done. Just, I'll take the deal.
Right. Exactly.
So when it comes to just business docs, right? Just some documentation, some key things that should be in place. And I want to put this in perspective for the people who are listening that are business owners, right? There's 2 aspects of a deal when it comes to the value of a business. One is the profitability of the business, right? So it's got to be making money. If you're a SaaS company or a new startup, it might be a revenue play, but for the most part, it's some multiple of either seller's discretionary earnings or EBITDA, but some profit metric. But there's a multiplier, right? 3 times earnings, 4 times earnings, 2 times earnings.
Right.
we're really talking about, your profits are pretty baked in at the time of a sale. There's not a lot you can do to move that needle in a short period of time, and they're looking at probably the last 3 years typically, and making a forecast of what future profit looks like. But we're talking about affecting that multiple, and it takes some time to do that. We want you to turn your 2 times into 3 times, into 4 times, into 5 times, and business owners have direct control over that. And there's certain things they can do to move that. And one of them is just how clean your business is, right? And so what are some of the documents that business owners, wherever they are in their process right now, really need to, like, hey, I need to go back and ask the question or look these over, make sure they're correct and they're up to date? What are just like the basic key ones that they need to have in place?
The great part about this, Craig, you ask all the right questions here, and your listeners are going to either love it or hate it, but I have a transaction example for almost every question that you're asking here. So the business documents you're going to want to make sure you have in place. You want to make sure, one, your business is still an entity. This sounds funny and goofy. I was in a transaction halfway through, and I looked at who the counterparty was. We were purchasing just some IP from a company. It's about $2.5 million purchase. It wasn't huge, but it wasn't insignificant. Purchasing all this IP, and so I look at the counterparty, and they say, "Hey, we're a New Mexico limited liability company." All right. First thing I do, New Mexico Secretary of State website, go and look it up, make sure it's a good business. Dissolved, meaning the business
Wow.
doesn't exist anymore legally. And so I said, let me try this again, and then check it again. Dissolved. Checked for all the different changes of the name. Then I check with the other attorney. I say, hey, and this other attorney, by the way, is getting paid extreme amounts of money. They hired big bad, law firm that everyone hates, 4 digits an hour. And I say, hey, your client dissolved their business in the middle of this transaction. She said, let me check on that. Okay, screenshot, here you go. Comes back, yeah, they did. I said, well, that's a problem. The business that doesn't exist is selling us stuff. So we found workarounds. They ended up having to sell the assets personally, which is never great for a seller, because then you're tied to those liabilities that stick with it as well. But all that to say, as representing a buyer, those are the things that you're looking for during that due diligence process. You're looking for all the ugly things that a nefarious seller could do. So when you're representing the seller, your job before you even get interested in getting offers from buyers, before getting to an LOI type stage, or even an RFP stage, what you're going to want to do is clean up. Make sure your certificate of formation, articles of organization, whatever your state calls it, your formation document, which creates your LLC. If you're a corporation, it's going to be you're just going to have articles of, not articles of organization, articles of incorporation, excuse me. So you're going to want to make sure your business is in good standing with the state. That's like the absolute first thing you do. The second is make sure that you have an operating agreement. If that operating agreement is out of date, it's time to amend and restate it. We're going to make sure that this operating agreement looks clean for a buyer, because those are the first 2 items that I'm asking for when I'm representing a buyer. Say, does your business exist? Which should be a gimme, which it wasn't. And then second, let me see who actually owns this business, because your operating agreement will typically show your cap table. You'll uncover things like a right of first refusal if they're trying to sell assets, and make sure that, hey, before my client, the buyer, is buying this asset, does anyone else get first rights? Am I just being used to get an offer here? And then they're going to go offer it to their business partner, which is required under the operating agreement, right? So those are some of the first things that you're going to want to do and make sure you're ready for due diligence. Your second piece is you're going to want to make sure your contracts are all sorted out. That's going to be your vendor contracts. If you have a significant vendor, so for example, if you're a software business, this is going to be your AWS, it could be Cloudflare, whoever is supporting the online aspect of your business. If you're more blue collar side, let's say that I'm representing an HVAC company. Well, you've probably got preferred pricing with Train or whoever else. I'm not going to plug any more names. I don't get paid for that. But you've got all these HVAC companies that you're getting referral bonuses from, you're getting promotional pricing. You want those agreements to all be in writing, because that's the next thing that I'm going to look for as buyer's counsel is, okay, you've been buying each unit for $2,000 and reselling for $5,000. That's awesome. Show me why you're allowed to buy for $2,000. And if you don't turn anything over, they say, hey, this is retailing for $4,500. So instead of that $3,000 markup, we're going to have to expect $500 going forward. And that's going to devalue your purchase price. And so we're going to have to pay less for the business because in the Q of E, which is the quality of earnings, I'm going to see that I can't charge that going forward because you don't have it in writing, right? So that's another one. Make sure your vendor contracts are sorted. Client contracts, example time. I represented a crop consultant in Southern Georgia who was selling his business. Now, I mentioned the word contract to him and he was like, well, what do you mean? I was like, well, when you go to consult for farmers and do soil testing, what are y'all operating on? He's like, buddy, if I put a contract in a farmer's face, they're going to tell me to get lost. He said, I tell them a price and we shake hands and I send them an invoice and 98% of the time they pay it. I said, all right. So it was a little more difficult there. And like you said, 80% of businesses don't sell. That deal actually fell through because seller decided he didn't want to devalue his business because the buyer couldn't accept that. Most of his deals were word of mouth and on handshake, even with a 98% collectability. So make sure your client contracts are also all sewn up. Last one, employment contracts. If anyone has an employment contract, get it in writing. If they're receiving special benefits from the company, this not only protects the company, but it protects the employee who may be a key person in helping this transition occur. Because the first thing a buyer is going to do is step in and say, hey, I noticed you have a company vehicle. Like, we're going to sell that because we don't believe that's an asset you need. If you have that employment contract stating that specific benefit in there, you're protecting the company, you're protecting the individual, and making sure that the business thrives going forward. So those are a few of the immediate pieces. The one thing that you have to remember as a seller, when the buyer is doing due diligence, their whole purpose is to figure out what you're hiding. It's great that you're not hiding anything, or you think the only little pieces, are insignificant. But the buyer is paying tens of thousands of dollars for attorneys to go pick through all your documents. And those attorneys, if they get paid $10,000 and say, we didn't find anything, the question is then, why did we pay you to look?
Yeah.
So they're always looking for that justification. They're trying to show their own value and show their client, hey, you paid me 10 grand, but I just found this $5,000 issue. If you use a 3 times multiple, I just saved you 15 grand on your purchase price. That's net 5,000. Pay me again. So you always have to protect yourself as the seller. If the buyer's represented, make sure you're being represented at that stage too, and not just trying to save, a penny and just saving a penny instead of saving the dollar. That's what we're here for.
Okay. So, corporate documents, whatever those are, and however you're organized, having those in place, making sure that you're up to date and everything is accurate with the state where you're incorporated or states where you're operating.
Yes.
Employment contracts, operating agreements, vendor and customer contracts. So you got all these things in place. Is this a one and done, or should people be reviewing those on some sort of regular basis?
And it's super dependent. The it depends answer is so applicable. I hate having to say it, but it truly is applicable. Every state is a little bit different. LLCs are created on a state by state basis. There's not one big federal law where you create an entity. So for example, in Idaho, my clients have to file an annual report, and I do it on their behalf, stating who owns the business, where your registered address is. If you don't get your annual report in on time, they'll give you a little grace period with a penalty. But after that, they dissolve your company. So you have to be on top of that. If you've never heard of an annual report, please check it out. Like, please go to whatever state you're set up in, ask your attorney, say, hey, do I have an ongoing obligation? Delaware, for example, is going to have different franchise taxes and things like that. Alabama has a business privilege tax that's paid annually. Again, if you don't pay it, they will shut your business down legally. So I would revisit this every single year at least. But especially if you were about to go into a transaction or you have someone that's asking about your business, that is the perfect time to engage a business consultant such as Summit Achievers, or check in with your attorney. And together we can make sure that you're set up. So when the buyer comes to take that first look, They're seeing the business with all its makeup on, not like it just rolled out of bed after a long night. It's all about the presentation for the purchaser.
Definitely. Yeah, I operate out of the state of Florida and as an LLC, and I have to file that annual report. The grace period is there, but if if you're at the end of that grace period, it's $450 additional expense. And again, people let it lapse. It becomes inactive. They don't call it dissolved, but inactive. Yeah, so it's something very important to keep up with for sure. So, as I'm thinking about a listener out there, one of the things you said earlier, I'm thinking about the garage door business, or the small automotive shop, or something like that. You use the word cap table, and I'm just picturing somebody going, I better Google that. I don't know what a cap table is. Do you want to just explain that real quickly for our listeners?
Yeah, absolutely. So a cap table is just the long form is capitalization table, and that shows who has contributed money into the business, who owns percentages. So, for example, if your business had $100 to start, I put in $100 and Craig put in $100. Our cap table would likely say we each contributed, $100, and we're 50-50 owners. And so the cap table is super simple at a very basic level. This gets super complicated as you start dealing with larger businesses who may have stock options and those sorts of things. But a cap table is always going to be asked for in due diligence. Capitalization table, just look for who owns what percent of the company. And effectively, for a buyer, it lets them know who can make the decisions on behalf of the company.
Yeah, and also who's going to be paid, and who could hold up a deal.
Correct. Very important. And that's why the buyer, they're going to look at the capitalization table and see, okay, if we're 50-50 partners, Craig, what does our operating agreement say about being able to sell the business? That's why you've got to have the operating agreement up to date, ready to go. Because if we're at a 50-50 stalemate, I want to sell the business, but Craig wants to continue to operate it. The buyer's going to say, how are y'all going to deal with that? Your operating agreement doesn't address it. These are all things you can take care of in advance, make sure everyone's happy. But doing that before the purchaser asks the question will save you so much money and keep the purchaser interested.
Yeah, for sure. Yeah, thank you for clarifying that. So, you've talked about representing both sides, right? You've represented buyers, you've represented sellers, and they're not always motivated by the same thing. And one of the things that you have to look at are taxes. And so when you're looking at deal structures, right, there's asset sales, there's stock sales, and each one of those is going to impact an owner differently from a tax perspective and potentially a legal perspective. So what are some of the differences in how the business is packaged and sold as it relates to my own liability or ongoing liability, my taxes for myself or my estate? And what do we mean by when we hear the word reps and warranties?
Yeah. All right. There's a lot to unpack there. So Forgive me and feel free to interrupt if I get a little long on some pieces, but this is the stuff that I'm passionate about. I love it. So as Craig mentioned, the two biggest types of deals for small to medium business owners are going to be stock purchase agreements and asset purchase agreements. Everyone likes to think about mergers, put mergers to the side. That doesn't happen as much as you would think for a variety of reasons. So we're just going to call it a stock purchase and an asset purchase. Effectively, in a stock purchase, you as the business owner are selling your interest in this company that's below you, right? I like to think of it this way. There's a circle at the top, that's business owner, and then there's a line that connects down, and there's a big square, and everything in that square is the business. In a stock purchase, you're selling that line, you're selling that connection to the business. And in an asset purchase, you've got your circle, you've got the line down, and then you've got the square. In an asset purchase, you're selling the square that has everything inside of it, which it's not going to be an entity, but the entity does the sale, versus in a stock purchase, the founder themselves does the sale. So what does this mean for tax purposes, for liabilities? Who prefers what? So I'll get into who prefers what because it leads right into taxes. Your purchaser is going to want to do an asset purchase most of the time. So an asset purchase for a purchaser means that they get their step up in basis for what those assets are worth. It's tax advantage to them. When they go to sell in the future, it's a better outcome for them. The seller, on the other hand,
which means basically the step up in basis instead of book value. you're getting fair market value or purchase price as the basis now going forward.
Right, because a lot of those assets have likely been depreciated.
Yeah.
So your book value is going to be in the dumpster. If you've got a vehicle you've expensed over 5 years, that was 100,000, right? That's now down to zero book value. But on an asset purchase, you can actually step that basis back up to that truck might be worth 40,000. So now that truck's worth 40,000 to you versus $0. So a purchaser loves that. And you'll mostly see that. So that's the tax consequence side. The seller, on the other hand, is going to push probably for a stock purchase. This is where your lawyer, your business consultant, and your CPA are on your team. Get them all on a call, talk through it, guys, because there's different recommendations that'll come along the way. But just considering tax purposes, the stock purchase is going to be better because the seller is then able to take long-term capital gains, and you're not going to see as much on the ordinary income. If you're a seller and you're in the top income bracket, you're not going to want to pay 37% plus any sort of net investment tax, anything like that, right? You're going to want to get to that long-term, lovely capital gain rate of 20%. That's where you want to live, right? Plus, if you've been in the business for 10 years, you're getting an even better deduction under existing tax law. And this is going to be a quick plug. Make sure your transactional attorney and your CPA are up to date with the new tax law that's been passed, the one big beautiful bill. Love it or hate it, it matters to business owners. So make sure that you're taking a look at that as a founder. Protect yourself. Make sure that everyone's staying up to date and they're not relying on information they read 2 years ago. Yeah. It's all changed. It's back. So that's the tax consequences on a stock purchase versus an asset purchase. Now, on the lawyer side, as if I'm representing a seller, oh man, yeah, stock purchase all day, get everything out. So here's the difference between those on the liability front. If you do a stock purchase, your purchaser comes in, accepts the business as it exists. That means the good, the bad, and the ugly, right? You get to collect all the revenue that's been outstanding, but you got to pay all the payables that are still outstanding. And you're just taking the business as it exists. If you're being sued for employment discrimination, you're stepping in and now you own that company that's being sued for employment discrimination. So as a seller, the cleanest break is for a stock purchase. Now, obviously a buyer ain't going to like that, right? The buyer wants to come in and do their asset purchase because when they do their asset purchase, they can then come in and they can buy just what they want. They can pick out the assets and leave all the ugly stuff behind, which in my experience, asset purchases are way more common because of this legal liability separation aspect. They can come in, if you own an HVAC business, right? They can come in and buy all your contracts from you. They can buy your inventory. But the thing that they're not buying and they're leaving behind with you is that employee discrimination suit, right? They can do that in an asset purchase. And there's exceptions and little pieces here and there that make it change. But that's the legal liability side. The only reason, well, won't say the only reason. One of the other reasons you might choose one form over another is because of certain licenses and permits that get really hairy and are non-assignable. So this is getting into the weeds a little bit, but when I dealt with FERC, so anything that's a power plant that does interstate transmissions is going to be subject to federal law. A lot of times we ended up having to do some stock purchases when it wasn't really the best thing in the world for us because that business already had the permit in place. It's non-assignable. In an asset purchase, all your contracts are getting assigned to the new owner because it changes entities, right? So there's little pieces and minutia. You figure all that out in due diligence. So when you're doing your due diligence from the buyer side, you say, what is the revenue driver for this business? Can I continue this business if I just buy the assets? If there's permits in there that can't be switched and things you can't just easily take over without getting a stamp of approval, sometimes you can push toward a stock purchase. But for the purchaser, who typically drives the discussion about how they want the transaction to go, is going to choose asset purchase. Now, every deal is different. You will hear that from every transactional lawyer that knows what they're doing. Every deal is different. A buyer may have the leverage in one deal, and then in the next deal, the seller has all the leverage. The buyer's just dying for this business, right?
Yeah.
So whoever has that leverage typically can dictate how the purchase is going to go. I've been in deals where the deal form has changed mid-deal, which was super exciting when you're on a flat fee. And luckily, you spell out that scope. But when you switch from an asset purchase to a stock purchase mid-deal, that's driven by a lot of due diligence. That's driven by tax considerations. If you think about all those in advance as a founder, you can avoid those extra expenses that happen in process. Have your business consultant, your CPA, and your lawyer lined up and ready to go so that when you meet a buyer, you already know what's the best strategy for you, and you try to push that as much as you can.
So I could picture some listener out there going, well, hey, the way I protect myself and make sure I always get a stock deal is if I make sure none of my contracts are assignable. That's probably not a good idea. And in some cases, it's probably not even possible. But there are times when being a manufacturer's rep, for example, that may not be transferable. If you are, you might have a customer contract that's not transferable. Right. So I could see how that could cause a change through due diligence as those things are discovered. But again, as you said earlier, being upfront and honest and disclosing is everything you can disclose early on, and not withholding information really makes a deal much more likely to go through with less pain and suffering.
Absolutely. Absolutely.
So speaking of liability, let's talk about reps and warranties. What are those, and what does that mean to me as a seller and a buyer?
Sure. Yeah, no, that's a great question. So this is where some people get lost in the shuffle, and that's okay. Lawyers too that aren't experienced in this. So your typical, I'm going to use an asset purchase agreement because I think that's a little bit more relatable for the majority of cases. So I'll give you a quick breakdown of what that looks like. So in your first section is generally introducing the parties, who's doing what, who's buying what, and what's kind of going on here. There's going to be definitions, a lot of definitions. We love definitions as lawyers, and we want to reference them all up front in section 1.3. Here are all the definitions, and it's 4 pages long, right? And so I keep my finger there and flip back and forth as I'm reading documents all day. So that's going to be section 1. Your second section talks about the closing generally. When is it happening? Who's exchanging what? What's the purchase price? And you're talking through a little bit more of the mechanics. What has to be done in order for this deal to go through? So your third section is where you're probably going to start reps and warranties. So you're going to start with the seller's reps and warranties almost always. What is a rep and warranty? A rep and warranty stands for representations and warranties. These are statements that you are making to the buyer that you are standing behind. Effectively, anything that's not a rep and warranty, so long as it's not made with fraudulent intent, doesn't matter, right? Like your reps and warranties. So the first one in every single deal is going to be, I am a Alabama LLC, speaking on behalf of the LLC, of course. I'm an Alabama LLC. I'm registered to do business in Alabama. I'm legally existing, and I'm good to go, right? Like that's going to be 3.1. Then you start getting into nitty gritty as you go on. My ownership is stated. Your 3.2 is going to say ownership is stated. This is where you're going to show your cap table. Ownership is stated as exhibit 3.2 here too, or schedule 3.2. And on that schedule, you're going to have the cap table because you, as the buyer, need to confirm from the seller in that document that what you looked at is the honest truth. So this is what I call the trust but verify section. You've told me all this stuff. Now put it in the agreement. And you're going to talk about the assets that you're purchasing. So 3.3 is going to say, schedule 3.3 is a list of all the assets that are being purchased here. And they are all in good working condition, excepting ordinary wear and tear, yada, yada. And what is contained in those reps and warranties is the most important part of the document for me as the transaction lawyer. That is the most, if not the second most heavily negotiated section of the entire agreement. Again, every deal is different, but this is generally true. So in that reps and warranties section, your promises section, you're probably going to have a litany of things that are in there. You're going to promise that the financials you gave them are true. You're going to attach a copy on the schedule. And so that's all for the seller to say. Here's where having a good lawyer matters, because the word material gets in there in certain places, and material for the non-lawyer just means like it's a big deal, right? So you can make mistakes in your reps and warranties as long as it's not a big deal, right? But if you don't get these little pieces in there, and material is only one example, there's knowledge qualifiers, there's all other kinds of things that can go in. But you want to make sure your reps and warranties section is bulletproof. It tells the full story, but it doesn't overpromise. That's the goal for the reps and warranties. So that'll be in section 3. Section 4 is going to be the buyer's reps and warranties. Those are generally really thin. One that I always put in as the seller's counsel is the buyer is not relying on any other information that does not exist in this document. That is my favorite. You've done your due diligence. You've looked at everything. If you think something's important, you put it in the seller's reps and warranties and we'll talk about it. But I don't want to hear about this a month after closing. Well, we thought this. It doesn't matter. Brother, you look in the document, it's there. So on the buyer side, it's generally, we're not on the brink of bankruptcy. We exist as a business, and I've done my own due diligence, and I'm not using a broker for this transaction, if applicable. And that's the meat of your section. That's going to be where a lot of negotiations occur. Other than the indemnity section, that is probably the heaviest section that's going to be negotiated. So in short, for all the people out there that's like, wow, he just talked about nothing for 5 minutes. Well, it's your promises section. It's what you're guaranteeing to a purchaser. And there's fundamental ones, there's non-fundamentals. Again, getting the right lawyer that knows what they're doing is important. And this goes a little bit deeper, and it ruffles feathers. But I saw a post on Instagram or X the other day, and it was a screenshot from a billboard that was out on the street, and it was for a realtor. It said, last year we sold 536 houses. Your cousin sold 2. And so effectively it's saying like, hey, I know you've got a good relationship with your cousin and you probably want to list your house with them, but list with the person that knows what they're doing and has done this. This comes in a lot, and we see this mistake a lot for people entrusting their lawyers. The lawyer that you use to close your house, the lawyer that you use for a traffic offense or something like that, is not the lawyer you need to use most likely for exiting your business. You need somebody who's the expert, who can make sure that you are being protected the best that you can, who's been there, who's done it. You would not want somebody to you wouldn't want to rely on somebody just due to a personal relationship, but you do want to make sure that you ask the questions, ask the hard questions. If you get your questions answered, the person probably knows what they're doing. But trust is one piece, but experience, you've got to have the two together. You can't just trust someone's going to do a good job. Know that they have the experience to protect you. I have been a buyer. I've represented a buyer where a seller has gotten, I lightly use the term incompetent counsel, but counsel that was not experienced in transactions. And it was a clear win for my buyer. I'll say that.
Yeah, and I've heard those stories from buyers and buyers brokers where, they're not going to bring up the thing that's missing, very plainly missing from the agreement, because the seller didn't know, and they're going to take advantage of that because the seller has every opportunity to get counsel and do the right thing.
Right.
And they're looking for a deal. And whether you think that's fair or not fair, or ethical or not ethical, it's a contract that you're signing. And if you don't get the right counsel, shame on you. That's
right.
Something you should do. So you don't want to go with your next door neighbor's uncle's best friend who knows somebody that was an attorney doing something for somebody, right? You want somebody who really, really knows what they're doing, has experience doing it, has done it more than once, hopefully. And so when does a seller bring you into or a buyer, even if a business owner wants to start down the acquisition trail, when's a good time for a business owner to pick up the phone and call Addison or somebody who does what you do?
Yeah, Craig, it's a great question. And it's one of the fundamental mistakes you see sellers make a lot of the times. After you have signed an LOI is the incorrect time to engage your lawyer. It's not the worst time. That would be much later on. But the LOI stage is so vitally important to the seller, because if you don't get your counsel involved beforehand, you don't know what you're looking at in that LOI. But the seller, you're looking at the purchase price, right? Like, you're looking at the purchase price. When can this be done? That's really what you care about. And then maybe you've got family members who still work in the business, and the LOI addresses that. Hey, Gina and Timmy still get to work in the business for a few years. Great. Okay, awesome. That's not what I'm concerned with. I'm concerned with those things, absolutely. But when they put in the indemnity section where it says, hey, we're going to cap, where it's going to be unlimited indemnity and every rep and warranty is fundamental, like that means nothing to the average founder. And that's okay. I went to school for this and I've practiced this. That means a lot to me. And that means a lot to a founder for their liability. So getting again, your business consultant, your CPA, and your lawyer ahead of the LOI, all on the same page, is so important. There's a lot of things that you can do to be prepared for the purchase, but the LOI is the table setting. Look, you're going to start a feast with this purchaser. What you want to do is set the table in the LOI. If you come in, the tablecloth's ripped in half, it's going to be a terrible dinner, right? It's not going to be a good situation. Yeah. You want to make sure they're involved on the front end. That LOI, while it seems monotonous, it's just business people getting together. Look in the bottom left-hand corner of that document. Next time you're a business owner and you think you're just working with the counterparties like business, there's going to be a doc ID number under there with a decimal, and it's going to be a version number. That means they already got their counsel working on this. Watch. 50% of the buyers or sellers will look at that and say, I've never thought about that before. That means a law firm is already working on that LOI and you are outmatched. If you have not been working with an attorney, you are at a severe disadvantage. You don't even have to engage attorneys that deeply. An LOI negotiation is not a long process a lot of times. A lot of it's handled by business, and then we're here to be support when that final document comes in. But don't sign that document until you have at least consulted an attorney. If you sign the document and then consult an attorney, it's a lot harder for us to negotiate on your behalf when the other side just keep pointing to your signature and saying, they already signed this, we're not renegotiating, and you've locked yourself in.
Yeah, and I want to touch on a couple of things. One, again, I'm trying to be very mindful of the person who is out there every day just in the weeds of business and maybe sees a finish line coming, and this is the first time they're even starting to think about selling a business, and they're going, LOI? What is an LOI? So just real quickly, what is an LOI? And then I have a follow-on question specifically related to LOIs and how that can get a owner into trouble.
Yeah, so an LOI, very simply, letter of intent. It spells out what you're going to put in your agreement. It's not a definitive agreement that requires you to sell your business. If it's written correctly, I've seen mistakes, but it's just going to lay out. It's also called a term sheet. You'll see a lot of times, but it says we're going to purchase your stuff and we're going to purchase it for this much on this date, effectively.
Yeah, so it's kind of like we're definitely not married. We're not even really engaged, but we're very seriously dating. We're heading.
That's a great way to put it. Yeah.
But yeah, a couple of things. One, that I think business owners I see not pay attention to if they're not represented. Attorneys will catch this, of course, but one is exclusivity, right? So of course they're going to want to lock you in, and this is, if a market is hot, for sure, I'm gonna lock you in. You're gonna sign an exclusive LOI with me, which basically means you can't talk to anybody else while we're talking to each other. And the other thing is an expiration date on the LOI, because my son spent a lot of time in Hollywood, and one of the things that happens, and it's nature of the beast, is when people sell scripts, a lot of times people will buy the rights to a movie, or I guess even it can happen in literature with books and stuff like that, with no intent to ever do anything with it. They just want to make sure nobody else does anything with it. And so they sign this agreement, and basically the author of the script gets no money unless something ever happens or gets made, but they're just parking it. So you can't go shop it to anybody else. And you really got to be careful on the LOI side. Again, people might be very friendly, but they're not your friends. That's a business deal. And unfortunately, people will take advantage of your naivete and not let you in on the secret. So looking in that lower left corner, that's a great piece of advice. I hadn't even thought of that. So that's a new one. And then making sure there's an expiration date. And exclusivity can be fine if there is an expiration date. It's horrible if there's not an expiration date. So again, having that attorney is super important. And so when we think of a deal team, right? I come in as a business coach, a business consultant. We're really trying to move the needle on that multiple and the profit. So we're trying to make the business better, more attractive. We want you to be the prettiest person at the dance. We want we want somebody to want your business, right? We want you to be as attractive as possible in the marketplace and as valuable as possible. So we deal in this whole value acceleration, maximization space. And then we have CPAs that are at the table. We have transaction attorneys. We might have, depending on the size of the business, a broker or an M&A advisor, might even be an investment banker for a larger firm. How do you, as the M&A attorney, interact with the rest of the team?
I love it, honestly. And any experienced transactional attorney will tell you that the more people, and this sounds counterintuitive, but the more people on your side of the table, a lot of times is better, because although we all have different opinions and maybe looking at different pieces, we're all making sure that we've covered all that founder's basis whenever they're selling, right? So your CPA gets brought in for tax consequences. Your business consultant is there to maximize the revenue of the business and make sure your QOV looks great and quality of earnings looks great, and everything is set for that buyer to come in and buy it. And my job as the attorney is to make sure that we're selling what you say you're selling. We're not overpromising. We're delivering exactly what the agreement is, and you are protected so that you can keep as much of that revenue and as much of that profit as possible. So I generally love to get on a call, at least with the CPA, once during a deal while the client is on the call. That way, any questions that they have, if we have a difference of opinion, we can talk about it. It generally doesn't happen. We actually typically agree on 90% of things in deals. A lot of founders are, I will say, hesitant to involve that many people, because if Craig's there as a business consultant, I'm there as the attorney, and the CPA's there, that's a lot of hourly rates to be in one room. But getting that and connecting everyone up front and making sure we're all on the same page and we all agree with how this transaction is proceeding, that might take an hour. So if each person in that room, let's just say, is $200 an hour, that's $600 you just paid for everyone to be on the same page as you, and you to ask all the questions while everyone's in the room, rather than getting involved in a deal. Okay, now I'll involve the lawyer. Well, the CPA I talked to before said this. Okay, well, here's what I think. And then I've got to talk to the CPA for more than an hour, and we figure out how to structure this thing. I've got to rewrite deal documents that you thought were going to be a stock purchase, but now it's an asset purchase. So getting everyone on the same team and aligned ahead of time, you're going to save so much money. You're going to feel better about the transaction. You're going to sleep better at night. There's nothing worse than when you invite people on the team and they just bicker and argue and disagree about every little thing. Just get everyone. We're all here to support the founder as they exit their business.
Yeah, and I didn't mean to leave out my friends in the wealth management space and the tax and estate space as well, because you as the owner really need to protect your family and protect your legacy. And so you want to make sure that you have all your structures in place, the right kind of trust, the right kind of wills, the right kind of protection, having the succession planning conversation with the family, with key managers, people around you, maybe even sometimes bringing in somebody who's a professional at talking to families and facilitating those family conversations, because family dynamics can get really crazy when it comes to business, particularly selling a business and what happens afterwards and who gets what. So it's a bigger team, and I think owners really need to listen to what people who have done this many times have experienced, because we want you to be more successful, right? We did mention 80% of the business don't sell. There's to me, that's horrible, right? That's just tough. Blows my mind. But to me, there's an even worse statistic, and that's 75% of the businesses that do sell. When you circle back a year later, and this is from the Exit Planning Institute, when you circle back a year later, those owners deeply regret that. What a horrible adverb, right? They deeply regret the transaction. And it's not necessarily just the financial part, right? Are you emotionally ready to move on from your business? That's a whole separate conversation. And if you're relying on the business, which is often your greatest asset as a family or as an individual, it's very illiquid, and you're turning it into this liquidity event, this liquid
Right.
asset. Is it enough for you to meet your financial needs? Does it close the gap? And do you even know what that gap is? So there's so many questions that you don't want to have to face after the fact. You want to bring people in as far ahead as possible, at least 2 to 3 years before you're going to sell your business. Ideally much earlier than that. And you want to be running your business well from day one. But certainly give it as much time as possible. Oftentimes you don't have that choice. You've got an illness or a death or some other outside influence that's causing a change that's forced upon you. And by then it's a little bit too late. You can still mitigate some of the damage, but do it as early as possible. And Addison, I just want to thank you so much for taking time out of your day. I really appreciate that. I might send you a thank you package of ice cream just to try to convert you and get going. But thank you very much. I really appreciate you being here.
Yeah, no, I appreciate your time, Craig. I think what you're doing for people selling their businesses is wonderful. And I cannot say thank you enough for having me and allowing me to present a little bit of free knowledge for people out there who are the ones who truly need it. So I really appreciate the opportunity.
Yeah, thank you so much. Have a great day.
All right, man, you too.
Hey, thanks so much for listening to this episode of the Summit Series. Please make sure to click on the follow button on your podcast app so you never miss an episode of our show. This episode was produced by Paige King and was edited by Matt Huston. I'm Craig Huston, and you've been listening to the Summit Series.